Yes, it is actually more 1 million. Seniors are the administration. If they can consent to that, next site,
Another day
even the after 9, but any day after
after 9.
9, 9 to April.
This matter, you must be seeking disposal at admission stage.
Yes, sir.
So in that case, because if all matters come on the hearing list, on the hearing date, we can fix it on a non-hearing date.
Non-response.
And then after finishing the list, we can try. Mr. Mahajan, learned counsel.
In this matter, madam,
Yes, you are appearing,
you
you are appearing for the
statement.
state. So we'll fix another day. Council, the other side, seeks and adjournment. Found out some difficulty of the leading council. Please allow, please the matter, after 9 you said, after 9.
Well, after 9, there will be vacation. Well,
10 will be holiday most probably.
10 will be holiday, 9th is election day. So let it be after
After
Bihu.
vacation, after the Bihu.
After Bihu. Maybe on 24th April, man. 21.
Yes, that's what I was just thinking. 24/4.
Madam.
So, interim model can be continued.
Interim motor shall continue the next day of list. One of the writ petition in this case, remove.
Criminal 480. Both are permissible. Actually.
Huh?
Both are permissible.
Both.
Writ petition, criminal or
Yes,
480.
those pass by criminal. We'll see.
Obligation.
So item number 11. My senior counsel has gone to the hospital and his wife is admitted in hospital.
That's okay, no problem. We'll adjourn it, but very old matter. Kindly do it on the next or subsequent dates. Okay? Because it's, I don't know what is the state of 13 years been pending. Learned counsel, your good name, please.
Igor.
P. Bora, Learned counsel submits that seeks an adjournment of the matter on the ground of the leading counsel having to attend to his wife in the hospital. Prayer is allowed. Let us fix a date after vacation. After vacation, so then we get time to prepare also. These are all matters. It should be straight away after a month. 23. 23/4. 23rd April. Is it okay? 23rd April. Yes.
That's it. With the other birthday concern, item number 6. What's a plan, due to some personal business not appeared today. So that's it.
You filed the matter on IA for suspension.
Yes.
Okay, no problem.
That's it. Can it be on 31st March?
31st March. Oh. Six an adjournment of the matter. Please for listing it on 31st. List on 31.
I will please.
Yes, tell me.
For listing of people are well.
When?
26.
Diary is received.
No, diary not received, madam.
The case diary is not received. Issue a reminder for the interim being granted on 9/12/2025. Stands extended to the next step of this. This is the matter on, we can repeat because they have not come. Suppose they come, you can fix the date later.
Item number 3 may kindly be time being a PCR received, madam. I need to go through the same item.
It only 45 kg of minor cattle beef minor that has been recovered from the backside of the house of the patient.
Right.
Now, section 290, 296 and 299 not applicable in this case. And so far as the Exception Act is concerned, minor, section here, inserted section 517 and 30.
Mhm.
So far the 5 is concerned, the prohibition of slaughtering of cattle without certificate from the competent authority. So far as 7 is concerned, prohibition of transportation of cattle.
Mhm.
The 13 is concerned, whoever contravenes
Mhm.
the provision contained in the sections 4, 5, 6, and 7.
Not 8, not 8.
Not 8,
Not 8.
So I'm paying for my entry, my CDs, not, I don't know where to see.
CDS comes,
But CD not received, my lord.
not received.
Not received.
Last no occasion, my lord. It is not a serious offense, but yes, I'm admitting my lord, get a court people and that particular area, my lord.
Let him record his statement.
My lord.
It will be updated also. Yes, there. Third. Yeah, Ahmed. Get postal on additional PP invoking 482. The petitioner is seeking anticipatory bail in connection with Toboka PS case number 198 of 23. And that's what action. That is preservation. The case arose out of an FIR dated 10/10/2025 lost by police official on the Boca police with the allegation that the petitioner that information was received about involvement of the petitioner in slaughtering of cattle at the backside of his house and selling the said meat. That accordingly, it is alleged that the spot is located within a radius of 5 kilometers from the temple. Accordingly, the police party went to that place, but did not find the accused persons. However, they found 40 cases of suspected cow meat in abandoned condition. It is alleged that the petitioner has violated the provisions of the Assam Cattle Preservation Act 2021. 8 is also been given. And the case diary was called for, but today also the case diary is not received. And the Learned Council is for interim. Since there is some delay in arrival of the case diary, therefore, in the meantime, in the intervening period, the petitioner can be directed to record his statement for the police and narrate his version of events. In such view of the matter, issue reminder for the case diary.
My lord.
However, in such view of the matter, it is directed that in the interim, 30,000 with one unit, the satisfaction of the listing authority, subject to the commission that we shall cooperate, appear, shall not commit any illegal activities, including any activities violative of some cattle preservation, 1920. 2021, sorry.
My lord, next date, my lord.
Next date, take the date.
My lord, 23rd, my lord. After vacation.
24.
24th.
24, 4.
24.
Lordship, on last occasion, amicus was appointed, so but now my learned friend has appeared, your lordship, for 2, 3, and 4.
Okay, you are appearing in private
Lots-
custody.
Lordship.
And 2, 3, and 4, right?
Yes, ma'am.
What about one?
One is a state, my lord.
State. Well, you are
State.
appearing. 2, 3, and 4, the private custody. It's come up for orders. Now let me just refresh myself the last part. Just give me 2 minutes.
Lord, here, the petitioner has received the order passed by the trial magistrate on 27/10/21. By which the cognizance was not taken by the landed trial court.
Cognizance was not taken.
Not taken. And the cognizance was not taken, my lord. Only on the ground, your lordship will find at page 30, the order taken.
Page 30.
30. And it's a G.
30. Thanks. 27/10/2021.
My lord. Today was the date fixed for necessary order. Peruse the record along with the statement of the complaint. In his statement, the complainant has mentioned that on 19 to 17, he lodged an azhar at Bokajan PS regarding the alleged incident, which was submitted as final report. And on filing objection, same was registered as CR case number 7718 by the learned judicial magistrate Tipu Kardi and Law. Case 7718 is also fixed today in this court, and I have gone through the record. On perusal of both the record, it is seen that incident alleged in CR 7718 is the same incident in this case. On further perusal, it is seen that instant case is nothing but a filling up the lacuna. Since CR 77 already proceeded, cognizance on the said incident has already been taken. I do not see any reason to take cognizance from the matter already subjected. Considering all this complaint is dismissed accordingly.
Second complaint.
Yes.
It is a second complaint.
No, my lord.
No,
Initially, what happened, my lord? They filed an FIR. my lord.
let me complete.
Okay, okay, okay.
And what happened? Earlier, I'm referring the earlier FIR by which the 77 case has been arising out. That FIR Lordship will find at page 12.
Just a minute. Have you got a call? Because today, since it has come for orders, have you received the copies and all? You have received.
Now, my lord, one pertinent question is there.
It has been admitted. Has it been admitted? Because, yes. No, since it has come for orders, has it?
May I pray?
No, let me. I'll just check it.
Yes, ma'am.
It has been admitted. Admitted on 26th.
So, my lord, the earlier FIR,
I'll come to.
page 12.
Yes.
Page 12. With due respect, I have to state that I was working as a manager in the farm by the name and style of Modern Drug Distributor located in Dimapur, Nagaland on 5/3/2016. Dilip Das, who is the husband of one of the former partner of the farm where I was employed, had called me and my wife to come to his house in Bokaja for some urgent matter. As such, I along with my wife really went to his house in Bokaja on 6/3/16 at around 3 p.m. However, on reaching there, we were asked by Dilip Das to sign an affidavit, the contents of which were unknown to us. On refusal to sign the affidavit, Dilip Das, along with some of his wounds, threatened us with dire consequences and that our lives will not be spared if we refuse to sign in the affidavit. As such, fearing for our lives, me and my wife had signed the affidavit under duress and returned to Dimapur. It is to be mentioned here that neither me nor my wife was aware of the contents of the affidavit, except it was mentioned somewhere that I had received ₹5 lakh from Jarita Das and Juma Devnath, which is true that Jarita and Juma, the former partner of the farm, needs to pay me a huge sum of money, and to recover of this fact, Mr. Dilip Das has resorted to this email. Therefore, I would like to request you, kind authority to look into the matter and take necessary steps whereof this fraudulent affidavit can be seized and guilty punished. This was the initial affidavit, upon which the police has submitted the final report. Thereafter, one Naraji application was filed for the Learned Trial Court, and then the cognizance was taken by the Learned Trial Court.
Just a minute. Let me read this part, page 15, where the narration of the FIR final report is there. Narration of the final. Why final report was submitted? We can read that. Page 15, the petition.
And this Naraji application, which was conducted in CR case 7/20.
They are related now, right? Father-in-law. He is the father-in-law of the Nivdas.
Yes.
So
Thereafter, my lord.
could not collect evidence, therefore it was.
Yeah.
Then this was the Naraji petition.
Yes, Naraji application is there, and that matter, the cognizance was not taken.
Naraji petition was, cognizance was taken. It proceeded as a complete case.
Yes, my lord.
And that was pending matter.
Okay, this is the Naraji petition.
That Naraji petition is there.
Naraji petition is, my lord.
On the basis of this, the complaint case was raised to.
Yes, my lord. CR was registered, my lord.
Yes.
Thereafter, my lord, the second complaint case was filed. Second complaint case, you'll notice it will find
No, this,
at page 20.
what was this, CR 77, where is the cognizance order? CR 77.
Is that
On the basis of Naraji petition, CR 77 was registered.
Yes, that's
Right.
right.
77. 77 of 2018.
77 of 2018, my lord. And that was disposed of, my lord.
Huh?
Subsequently, it is disposed of as similar criminal appeal is pending in this court, my lord.
Against acquittal.
Yes, against acquittal. They have filed that appeal because that was disposed of, my lord, and that criminal appeal is, my lord, criminal appeal number 304 of 2023.
Anyway, I'll come to that.
Yes, ma'am.
That's our
Then, my lord, the second complaint was filed. It is at page 22, annexure E. Annexure is the second complaint. Here, my lord, the complaint is required to be read, my lord, everything will be cleared now from this. And reading para 2 at page 23. The wife of the complainant, namely Nampi Pal, and the accused Srimati Jalita Das and Yuma Devdas, were the partners of the firm, namely Modern Drug Distributor, which started in 7/7/2004 by executing a partnership deed amongst them, and the complainant was the manager of the firm. In the year 2015, while the business was running in the good position, suddenly the two partners, Jalita and Yuma Devdas, were illegally, by violating the terms of the condition of the above partnership deed, gifted their share part of the partnership fund in favor of one solely without any consultation with the other partners, namely Mumpy Pal. And thereafter, the said partners, Mumpy Pal, served legal notice upon the said two partners for their illegal gift, the share of the partnership by violating the terms and conditions of the partnership deed. Over the matter, till now, civil suit has been under adjudication under the said two partners, namely Jalita and the Juma Devna. The complainant, being the employee, manager of the Modern Drug Distributor, is entitled to get his long pending salary of an amount of rupees 42,41,028 to the accused number 2 and 3, namely Jalita and Juma Devna, respectively. Knowing the gift of the share of the two partners to another one complainant, raised his claim of aforementioned outstanding amount. As such, the said two partners assured that they would pay the aforesaid amount within a few days to him. Thereafter, the complainant awaited a few months and made regular demand of his said money, but the accused number 2 and 3, namely Jalita and Juma Devna, respectively, did not hit upon the matter. Finding no way the complainant bound to serve a legal notice through his engaged lawyer on 1/1/2016 upon the said accused number 2 and 3, namely Jalita and Juma Devna. Thereafter, on 5/6/2016, Jalita, who is the husband of the accused number 2, in connivance with the accused number 2 and 3, has told the complainant that his wife through messenger to go to his house for some arrangement. As such, the complainant and his wife had gone to the house of the accused Dilip Das and Jalita Das at Bokajan on 6/3/2016 at around 3 p.m. And after reaching there, the accused then with Dilipdas asked the complainant and his wife to sign on the affidavit. But the complainant and his wife refused to give the signature without perusing the content of the affidavit, and for which the accused number one, namely Dilipdas, in collusion with the accused number two and three, with their gang of miscreant, pretend the complainant and his wife for direct consequences, and as such the complainant and his wife bound to put their respective signature on the affidavit on fear. It is like we mentioned here that the accused number one shown one point of the said affidavit, wherein it was written that the complainant received ₹5 lakh, and the rest amount will be given to the complainant within 6-7 months. Thereafter, on receiving the said amount for their life, the complainant and his wife returned to their house at Dimapur. After awaiting for 6-7 months, while the accused person did not pay the remaining amount of money to the complainant, he again made demand to the accused number 2 and 3. Then the accused person informed him that they have already made payment of the entire amount, and to which the complainant and his wife allegedly signed an affidavit, where no such declaration was given by the complainant to an affidavit regarding receipt of the entire amount. From this circulation, the complainant lodged an FIR before the officer in charge, Bokajan Police Station on 19/2/2017. The accused person regarding possible obtained signature of the complainant and wife, namely Monty, by giving live feed, and the said was registered as a Bokajan case number 39 of 17, and the section 384/30 corresponding to GR case number 125 of 17. Thereafter, the police Bokajan station, without proper investigation, submitted the final report of this case. Thereafter, the complainant received the notice from the court, and IO has submitted FIR of the case due to lack of witness. The complainant was receiving the notice from the court, and knowing the matter had submitted a complaint case Naraji petition with a prayer for proper investigation of the case through the learned court, which has been registered as CR case number 7718, arising out of Bokajan PS case number 3917 and the 384/13 corresponding to GR number 125/17, which is now under adjudication in the Court of Adjudication Judicial Magistrate First Class Bokajan. It is like to mention here that the said case was under adjudication in the Court of Judicial Magistrate First Class Kardian Law. Thereafter, the said case has been transferred to the Court of Adjudication Judicial Magistrate First Class Bokajan from default to the Kardian Law for adjudication. Thereafter, due to long lockdown for COVID-19, the complainant could not attend the court at Bokajan and could not able to obtain the certified copy as required for the said case. That recently the complainant went to the court of Bokajan and applied for certified copy of the affidavit, which he obtained the certified copy of the affidavit from the record of the GR case number 125/17 on 26/11/2020. And he found that affidavit on which the complainant and his wife put the signature on peer has many discrepancy with the said certified copy of the affidavit, as the same was not tally with match with the affidavit on which they put the signature on peer. It is like to mention here that the affidavit on which the complainant and his wife signed on 6/3/16 on peer, wherein it was written at a particular point of time the complainant received ₹5 lakh only from the accused as a part payment, and the remaining balance will be paid within 6-7 months as shown by the accused person. But in the present certified copy of the affidavit, wherein point number 4, it is clearly written, as the complainant received a bonus of ₹5 lakh on 27/2/16 from the accused number 2 and 3. Moreover, column number 5 and 6 and the last paragraph of the said affidavit also fabricated statement, and the said affidavit does not bear store or reflect notary's name, seal, signature, except registered number date thereon.
Anyway, just we pause for a moment here. You said that criminal complaint case CR number 77 of 18 proceeded to full trial.
Yes, my lord, disposed of. I'm having the
Well,
judgment and the
disposed of
criminal
and-
appeal.
Just a minute. The criminal appeal is pending against that
Yes, my lord.
for this court.
Yes.
I think since the matter has been admitted and today
Yes,
it has come for orders and you have
Both
appeared.
take together
So
and
it-
maybe
What is the stage of that criminal appeal? Is it just sorry? I'm just.
it is fixed for hearing, my lord.
It's for, should we tag that?
Yes,
Because,
my lord.
Because this can be, put,
Yes.
this is rare. This is a 21 matter, even if we fix it for hearing.
Only point involved is that, my lord, the trial magistrate did not give any reason for not taking cognizance.
So he has given a, no, he has given
The
a
entire
reason.
matter rests upon that. My
He-
lord, section 203 speaks, my lord, if he dismisses
Let
the
him-
complaint,
let it-
give some reason. Only reason is given that the perusal, it is appear that instant case is nothing but a filling of the vacula. Yes. My lord, that is the reason.
Yes, given
He
the-
has to take, he has to take.
Oh, the merit of that reason can be
Yes.
is subject of this adjudication.
What my lord would appreciate is that same two complaint case pending in the same court. Now the trial judge has rightly pointed out the other case is also pending before my court. Kindly see the third paragraph at page 30. my
At
lord.
that time, it was not disposed of.
No, at that time it was not disposed of.
As
Because
anyway,
it was
so
disposed of
we'll not-
only on my lord,
Will not go very much.
17/7/2023.
The thing is that the second complaint, the law regarding second complaint, whatever I know, is that it's on a very limited
Very
window.
limited scope.
There is a case from Assam.
Yes, my lord.
Talukdar.
Yes, my lord. I have the citation. My lord, I can place.
1960s,
Yes,
1960s.
yes, 60s case, my lord.
That's a leading case on second complaint. Of course, the law has developed a lot after that. But anyway, but that is after disposal of the first complaint. The magistrate now in this case has said that at that time it was already pending. So I
Yes.
think in the meantime, there is subsequent development, sir, that this has been disposed of. There is also an appeal. So it will be best for the interest of the merit of the matter that we'll fix this for hearings together with that appeal, and it will be easier for both of you to address the issue together.
Because my lord, why I'm making this submission is that FIR is of 6/3/17. Now, my lord, the Naraji was also on 6/3/17,
Person can have
and thereafter the
grievance with
subsequent
FIR.
one is also on 6/3/17.
A person can have a legitimate grievance with a
Yes,
FIR,
yes,
no doubt.
definitely, my lord.
But we have to see whether this was justified or whatever. It will be easier to see with this.
Because, my lord, they have led evidence, my lord, in the evidence, they could have improved their case by
Anyway.
placing relevant documents, my lord.
I'll narrate a few facts which will be
Yes, my lord.
useful for the take this that court, whichever court takes up the next step. Third, sorry. Learned counsel, Mr. Tiwari appears on behalf of respondent number 2, 3, and 4. Respondent number 2 is the state. The learned amicus.
My name is remain, I can be typed off.
Let her remain, my lord. Let her remain.
Amicus. Usually, when private counsel appears, the amicus is
My case is
discharged.
not required.
I'm not safe.
Usually is discharged.
And now the recent Supreme Court judgment says otherwise also. Now even if the amicus is appointed, my lord, the accused has to be noticed on that, my lord.
Some.
And only once the
Hussein had earlier appeared as amicus. In this case, Mr. Tiwari, somebody said perhaps the learned counsel, Hussein can also contribute. An FIR dated 19/2/2017 was lodged by Gopal Paul. Making allegations against three persons in the said FIR. The case was registered as Bokajan PS case number 39 of 2017 under section 384 of 34 IPC. However, after investigation, the IO was pleased to submit a FR/closure report on the ground of not finding evidence. Full stop. Agreed by the same, the informant submitted a Naraji/protest petition before the Court of the Learned CJM Karbi Anglong before. On the basis of which a complaint case was registered, the CR number 77 of 2018. Subsequently, the informant as complainant filed another complaint before the learned trial court, whereupon CR number 7 of 2020 was registered. But by the order dated 27/10/2021, the learned JMFC Bokajan Karbi Anglong dismissed the complaint on the ground that similar complaint registered as CR 77 of 2018 is already pending. Voted for. Agreed by the said order dated 27/10/2021. The instant criminal petition has been filed seeking interference with the said. Mr. Tiwari, appearing for respond number 2, 3, and 4, submits on the other hand that CR 77 of 2018 proceeded to trial, and after completion thereof resulted in acquittal of the accused. The complainant agreed by the same has filed a criminal appeal before this court against the acquittal, which was registered as criminal appeal number
304 of 2023.
304 of 2023, and the same is stated to be at the stage of hearing. Upon perusing the case record of the instant proceeding, I find that the criminal petition was admitted on 26/2/2020. Scan PCR is already available. The parties are represented, and this case is also ready for hearing. And therefore, both the councils are also agreeable to listing the matter for hearing and perhaps tagging with the aforesaid criminal appeal.
Since the issue are similar, my lord. Since the issue is similar.
That's okay.
Yes, my lord.
So,
Well, a date may be fixed, my lord.
I don't know what is the date of that.
But that no date is fixed. That is why I'm saying
No date
that
is
no
fixed.
date is fixed. That is why I'm saying.
Is the matter for hearing on so and so date along with criminal appeal number.
304 of 2023.
That will be best.
Yes,
23, right?
yes, 23, my lord.
On this, after the first week of payment.
First week of May, any day, my
You
lord.
can choose a date.
My lord, 2nd of May, 3rd, any day, my lord.
2nd of May, first is holiday, second,
3rd, 4th, whichever is convenient to your lordship.
let us fix it on 5th May,
My lord.
5/5, huh?
Yeah.
It will come up, it's 21 May. So this will, narration will help also. Whichever, if it comes up, another bench.
Deeply obliged, your lordship.
Sorry, Lordship, I could not appear in item number 2, Lordship. I was in court number 19. Sir.
Well, no, it's okay. CD has not come.
Yes,
So I have issue remind,
Date-
interim,
date.
interim is there,
Lordship,
interim is there.
interim is there.
Interim extend. Date I have not fixed because you were not there.
Lordship,
Now you take the date. Which date? Choose a date
any date, Lordship, after being,
after. 22, 22/4.
Mas.
Date of mine. Sir, sit date.
Sorry,
24.
almost 9.
Something.
Yes,
You ready?
yes, my lord. I have gone through that, my lord. My lord was pleased to, my lord, grant interim bail, my lord. The present accused petitioner by the order dated, my lord, 9/1/2026. As per my lord, obeying this order, my lord, he appeared there, and my lord, 2/3/2026, learned JMFC, my lord, granted him bail. Now, my lord, regarding the, my lord, the part of the city that is not available, only, my lord, the search is available with us, my lord. City is not available. Otherwise, he was granted bail, my lord. He, my lord, his bond is, my lord, there. I have flag marked that order. The city part is not available. my lord.
He appeared and he will continue to appear. I started my. I may be. Out to the name of the.
The allegation was serious. Because of that, my lord was pleased to call, my lord, that is the 3CR, my lord. In the vernacular, my lord, that is, my lord, allegation against the present accused petitioner. In the vernacular, my lord, Murot Dhap Diat, Mur Samie,
Allegation.
so because of that, my lord was
But
pleased to call that.
now,
Permanence.
it is at the stage of appearance.
Yes,
Charge sheet is submitted.
some. CD is not available, my lord. CD part is not available. Search is there, my lord.
Rashid has cognized.
Mr. Our order to 9136. Para 1, 2, 3. The petitioner was granted interim bail on 9/1/2026. Pursuant to which he appeared before the court of the learned, the JMFC, Nagaon, and submitted fresh bail bonds. Submitted bail bonds in terms of the interim bail order. And The same were accepted by the learned journalists. The prosecution submits that the case is already charged sheet. The learned counsel for the petitioner submits that cognizance has also been taken and the case is at the stage of appearance. And as mentioned above, the petitioners appeared before the petitioner appeared before the learned court pursuant to grant of entry in law. In the circumstances, I do not deem it necessary to cancel the entry. Accordingly, the same is made absolute, subject to the condition that the petitioner shall be available for trial. If one commences, he shall not hamper or tamper with it. With petition, he shall not intimidate or harm the informant or any witnesses, informant side or any witnesses. The bail petition stands allowed and disposed. No. We have come 4 bail petitions. You are for the bail, which matter, but
Item 7.
item 7. We will some, when they come, I know. Very old hearing.
Yes, my lord. Here we have challenged the order of maintenance, my lord. In fact, during pendency of the proceeding before the learned family court, the wife, my lord, that is the respondent number 2, she entered into a second marriage. And this is reflected in the, my lord, deposition of PW2 also, my lord, Alex, my lord. He is independent witness. Page 36, my lord. And I have also included her second husband as respondent number 3, my lord. Notice was also served.
Munima Begum. It's been a
Page
long time.
36.
I was thinking what is, I don't know what is left in this. I mean, it was originally the impugned order was passed by.
Passed by, my lord, the principal judge family court, Kamru.
Mr. Boso, I think though you're not here, are you one of the respondent?
Yes, my lord.
Yesterday, we had taken up this issue.
Ukon is there, my lord.
This will, that notification is there, no? It has to, nowadays revisions are also being placed before division bench. Right?
Right.
Yesterday, we had discussed
My,
in the division bench. Though it is, in my opinion, it's not necessary, but that's there's a notification of registry. That's registry notification. There is a notification of registry 22. Notification of the registry which says that all orders and judgments of family court to be placed before this special DB. Special DB. Family court. This has to go before family, division bench now, special division bench.
notification also, no?
See what, after refreshing yesterday, only this matter had come up.
Yes, sir.
When I was in the special meeting. That, as per subsection 6 of section 19, subsection 6 of the Family Courts Act, any appeal has to be heard by, you have a family court. Can you take up the family court? Or you can take it from this, I remember. Kindly see family court. 19(6), any appeal has to be heard by 2 judges, division bench. He does not speak of revision. 19(3) or I think 19 subsection 3 pertains to revision. Okay, 3 or 4, most probably 3. So it pertains to revision. So it is silent about revision. So that means for appeal from family court, division bench is essential, but for revision, it is not essential. However, there's no bar in giving. It is not essential. So we were hearing single bench matters from family court revision side. But now, since there's no bar, however, so we cannot say the notification is wrong. We cannot say that also because there is no bar. appeal it is essential, but
Yes.
revision it is not essential.
Yes, Your Lordship.
So since there is no bar,
Hmm.
notification says that all revisions have to be before the division bench. Such an old matter also.
Yes, Your Lordship.
How long it will remain, you know, it looks bad also. We should dispose of these matters. It looks very bad on the, you know, on the docket.
Respondent number 3 did not confess, right?
So, it was. You are private counsel, right?
Yes, I am legal aid counsel.
Legal aid counsel. She was, what was the order?
It's at page 40, my lord, for payment of maintenance. The last page, my lord, page 45. The party should provide a sum of rupees 1,500 per month to the petitioner. Page 45.
She would probably, if it is per se, if the order is subject to correction, if the order is upheld, she will get it till the date of her second marriage. If she has
Yes, yes,
contracted till then, after that she'll not get.
Yes,
But till then she'll get under 125, right?
yes.
125.
But during pendency of the my lord, proceeding before the learned family court, she got married. And this is reflected at page 36. Your lordship may kindly see, my lord, she is an independent
But
witness.
she is not divorced, right? The earlier marriage, did she divorce
The
the?
opposite party has married now, but now she is married and she has got children also.
Yes, but she,
And
did she messed up? Did she divorce the petitioner? Her
she
first,
just left and she got remarried, my lord.
not-
And we made her husband, respondent number 3 in this case, my lord. Respondent number 3, Muhammad Nipul Ali. He is the husband, second husband.
notification, but can you get the notification? Can you get it? But yesterday only I had seen, so I remember. So, I don't know. Not very often, not very. During the proceedings, she left the first husband and married second husband.
Before that, she left, my lord, and she remarried, my lord, during the proceeding, my lord. She left the place of the petitioner and then she filed the maintenance bill, and thereafter she got married, my lord. It is reflected at page 37. The opposite party is married now about a month back.
Wife includes a woman who has obtained or has been divorced from her husband and has not remarried.
So since she is remarried, she is not entitled. And this fact was brought to the knowledge of the court, my lord, by the petitioner by filing an additional affidavit, but that was not, my lord,
I see.
my lord, reflected in the order, my lord. I have annexed the additional affidavit also at page 38. Annexure F.
This may also come to your, I mean, this may also be relevant in subsection 4 of 125. Kindly see 125 subsection explanation, subsection 4. No wife shall be entitled to receive an allowance for maintenance or interim maintenance if she is living in adultery or if without sufficient reason she refuses to live with her husband, or if they are living separately by mutual consent. Leaving the husband without divorce and remarrying another person could be something like that, living in adultery. Anyway, we will not be able to enter marriage, so it has to be placed before division. What is the spirit behind giving the appeals of family court to division bench? Probably the registry on the administrative side, they have probably thought that since appeals lie before division, that's the same spirit lies. So revisions also But there is an anomaly because the thing that the same divorce petition, the same maintenance orders from district judge or session judge are heard by single bench. Same matters, the same matrimonial matter. If it is from Sipsagar, it will be heard by division bench, that's a single bench. And if it is from, say, family court Borpeta, will be heard by. So anyway, SB, learned counsel for the legal learned counsel or legal counsel appearing for respondent.
Number 2, Your Lordship.
Respondent was 2.
Yes, yes.
The petitioner herein who was married to respondent number 2 is aggrieved by the order dated, judgment and order dated 19/11/2010 passed by the learned principal judge family court, Kamrup Gauhati in FC Criminal 32 of 2008, whereby allowing the maintenance proceeding filed by the respondent number 2 as first party. The learned family court was pleased to grant her a monthly maintenance of rupees 1,500. Full stop. So Choudhury learned counsel for the petitioner submits that during the subsistence of the maintenance proceeding itself, the petition, the respondent number 2 / first party had left the petitioner and married one Nipul Ali, who has been subsequently impleaded in this petition as respondent number 3. None appears on his behalf. With that you have to, it has not been necessary to.
Before filing maintenance list, he left the application.
It is submitted that in view of her second marriage during the subsistence of the maintenance proceeding itself, she was not entitled to be granted maintenance, and therefore the impugned judgment and order granting her monthly maintenance is erroneous and requires interference in this criminal revision. Before proceeding further, this court takes note of notification number so and so dated so and so issued on the administrative side of this court, whereby all judgments and orders passed by family court on both the civil and criminal side have to be heard by the division bench. In view of the said notification, this matter may be placed before the special DB. Let us fix a date for you, short date for you. What do you say? Take it. Take it. Take it. This week also you can take. We are also sitting.
Yes, yes.
I've become partly familiar with the matter. But will it be
After Bihu, Your Lordship.
after the
Yes. 21?
Tuesday? It will come up in the first, as a first item.
Yes.
Yes.
In the hearing list, in any case. Whole matter. Please strong. With the consent of learned counsel of both sides. This is the matter on 21/4/2026 for hearing. For the special deal.
Oblige.
In no district of Upper Assam, there is family court.
Yes.
This one grievance of the past, you know. It should be. In Nagaon also, there is no family, surprising. We should set up that.
Where did you worship? Passport ID.
Okay.
Lordship, I have got a small prayer, Lordship. In fact, I have to leave by 1 o'clock. My son is having some exam. Hope it is taken up after 10-15 minutes, Lordship.
After,
After 10-15 minutes.
No problem. No.
Oh, he's come.
Science exam is very important.
So you must try to put over 8 lakhs.
No issue.
But the coexist by the surrounding portfolio, that is 76 lakhs. I have mentioned Lordship, out of same body. Ground of Bihan Kumar case.
You're receiving notice.
Yes, Lordship, notice pays 75%. Extra 7 pays 75.
And there's an earlier order, right? The subsequent bill application,
Yes, Lordship.
rejected.
And order pays 72 Lordship.
Really? What is the stage of the case? Oh, yeah. This week.
Yes, Lordship.
7 out of 13 witnesses.
Yes.
Well, let's progress. That's good.
Yes, Lordship, pounds Lordship.
21C, right?
21 C Lordship.
Progress. Before, Kamru,
Rongian.
additional session.
That's Rongian.
May I? Please, your lordship. Lordship, in fact, I have gone through the records and perhaps your lordship will be guided by the order dated 12/2/2026, which my friend has enclosed as Annexure 8. Because I do not see any difference in the materials in the case diary, lordship.
Pays 76%.
Page 76.
Yes. No, this was the earlier format.
Yes.
So
This was the earlier format. Earlier, everything, all the notices were like this.
it was like this, lordship.
Can be helped. Can be helped. That was like, they didn't know.
They didn't know.
Oh, shit, it's a gradual process.
That's what I have.
If it is retrospective, the law is prospective, then it's if it's retrospective, cover everything. But at
It will
that time,
cover.
not only the police, even we were not aware. We are learning.
In fact, after Vihan Kumar, there has been some development in some other cases, but again, we come back to square one.
Yes. No, these all cases. Because
Yes.
thing is that
Yes.
now if there is on serious matters where some custody may be necessary on merits, if now the procedural infirmities are there, then it will be unfortunate. Then it will be a loss for the prosecution. But at that time, nobody knew.
Of late, worship, what I have
They are
noticed,
taking care, but still, this is something.
if we leave apart this case, lordship, I do not find any consistency of late in the Supreme Court as well.
No, it's an evolving law. Actually.
Yes, lordship.
The evolving law. Darshan is come.
Darshan is there.
It's an evolving. Ultimately, I think it will settle. It might, in my guess, is that ultimately it will settle at substantive complaints.
Yes.
It might, or there may be a distinction in serious cases. Substantial complaints might be sufficient. Anyway, so in any case, he is in custody for a long time, and trial has also progressed.
Lordship.
So as long as he does not abscond, so
Lordship. Because on the perusal of the case diary, lordship, I marked a few pages, the same flags I have used. I do not see any difference from the case which is relied upon by my learned friend at page 76. He is a co-accused, and the papers are all the same.
so same.
Out of same wording.
Notice is same. No?
Same.
Same.
He's in custody since 2622.
Yes, Lordship.
Long time. So,
3 years, 9 months, 22 days.
but he should, he should not abscond.
He should not abscond. That has to
That
be
is the
lordship,
only concern.
secured. That is all.
Story के हमें लाख council. आके reach हो गए. आने deputy SG. Have a please sit down. ये जो करेक्ट discipline have for page 72. Adam, 2, 3. 4 and 3. 2, 3 and 4. This is a subsequent bill petition. An earlier bill petition was rejected on 24/11/2025. Passed by this court, DA 3115/2020. In this subsequent petition, the petitioner is seeking the benefit of non-compliance with the requirements of notice under section 50 of CRPC. A copy of the notice which was under section 50 CRPC, which was given to him at the time of his arrest on 3/6/2022 has been annexed. The said notice will be reproduced here in the reproduces. The scan PCR as called for has been received. The children are, is yet barely submits that. Notice which has been annexed with the petition, it's the same notice which is found in the case record. Prosecution, however, expresses the concern that the event of being granted bail, suitable conditions may be imposed so that the petitioner does not abscond. The petitioner, Mr. Ahmed, learned counsel for the petitioner, has relied upon an order dated 12/2/26 passed by this court in BA 130 of 26, pertaining to the same case being NCB crime number 14 of 20, same one, right? Same one, whereby on similar grounds, the co-accused was granted bail. It's well settled by now that the notice and that well settled by now in terms of the law laid down in, we give three decisions. Probably broadcast. We have we hear we just review. Grounds of arrest in reasonable detail and specific to the person have to be furnished to the arrestee, who has to fulfill the mandate of Article 22(1) of the Constitution of India. In the event of such failure, the continued under-trial detention of the petitioner would be untenable and it's not to be granted bail. It should be so, even if statutory bars on bail such as section 37 of the Indicates Act are. The instant case, the aforesaid nature of the notice, which incidentally was the usual format at that time, would not satisfy the mandate of the law laid down in this decision, of which have not been held to be only prospective. According, the petitioner has to be granted bail at this. In any event, he is in custody since 6/2020, and there is also progress in that. Accordingly, it's allowed to be on time. How much? 1 lakh? 75,000. Once you reach your the satisfaction of concerned learned, subject to the following condition. It shall not abscond, will be available for the remaining time. It shall not temper or temper with it. Shall not indulge in any legal activities, including any activity of consuming or peddling of illegal drugs, violation, bail condition, entail cancellation, bail petition stands disposable.
That's
Seven acres were arrested. Out of them, 24 has been paid.
Diary is come.
The diary comes.
What's this?
Yeah.
Same case.
Same case. All are same minor.
Diary
Yes,
was,
minor,
it was called for.
diary was called for minor. It is combined.
What is the progress of investigation?
Progress is that minor. Their statements are there, minor. Other rules. Then dispute occurs, minor. They say that minor, there one minor pistol-like thing, minor. Some minor, co-accused was granted bail, minor. Yeah, it is said that that was a lighter minor,
Right.
actually. I think it is mentioned in minor that is
He was arrested on all these
97.
26, same day.
all are in the
Yes,
same
sir.
day, my
Same.
same.
You can order. Era 2, 3, 4. 2, 3, 4.
Co-accused order এটা কাটিছে নি?
2, 3, 4. The learned counsel submitting the relevant orders in this regard contains that three co-accused.
Yes, Lord.
Three co-accused have already been granted bail.
Four accused has granted bail.
Four co-accused have been granted bail by this year in different bail petitions, some of which have been annexed. I perused the order dated 13/3/26 in BA 635 of 26, granting bail to co-accused Vedic Modi. In the meantime, his diary has also been procured. Seen the progress of investigation. Considering the progress of investigation and the aspect of merit, the allow this bail petition according the same questions. 9 to 12. 9 to 12. Of this. Picking. You want this back? No. You can give it. For writing the order, yes. Yes. It's possible. Well, all three are same. All three are same.
Yes, Lord.
15, 16, 17 are same.
Same minor. 15, 16, 17,
16,
same,
17, same.
same footing.
আচ্ছা।
There's a paper book. Yeah. The paper book is there. Very old single bench bill. He must be on bail, I'm sure. 2012, lady. She must be on. Nobody is here. Mr. We could have done. Could have done this. Paper book is also, you have the paper book. I know my. It's there. What about- That's me. Here. Proceed to the next matter.
Otherwise, my lord, legal aid or amicus will be appointed in this matter. Otherwise, my lord, legal aid or amicus may be appointed. 2012 matter, my lord.
Huh?
2012 matter, my.
Is it? Can fix it on Thursday or next Tuesday. Okay.
My.
You'll receive the paperwork.
My,
Paperwork you can receive.
my,
Paper,
my lord, I think, my lord, there is a extra copies available, my. I think.
Extra copy.
Available.
I have seen 2 copies.
My, then, my lord, we can, my lord.
I have
see
one
it.
copy.
Oh, yes.
I want to. None appears on behalf of the applicant. Paperwork is already available. In the case report. I don't know whether they have taken the paperwork or not. That also I don't know. Will you take one set?
My lord.
One set of the paperwork furnished to the neighbors of learned edition. Since this is the matter pertaining to. It was furnished earlier, someone.
My lord.
Someone. Since it is matter pertaining to 2012, requires to be disposed of. When should we fix it?
Immediate, my lord.
Next Tuesday. But. One, 3. Hold on. What is the old match?
Item number 9.
The instant criminal petition has been filed by the petitioner, agreed by order dated 12/4/2012, passed by the learned JMFC Udalguri, granting a monthly maintenance of 1,500 to the respondent. Respondents / first one. None appears on behalf of the petitioner as well as the respondent. These things are almost abandoned, but it is showing in the docket. 12,000, 12 pending, 11 pending. This possible. Is the matter on? This also fix it on. 30%.
Item number 10.
Yes, sir.
That is whether it is a proceeding. Or a platform that Minister of People issuing some of against that petition. They can be that the someone who has filed a complaint. Instead of complaining before the police there, even petitioner and of them leaving their house. So say, you can rupees 50,000. But it was not returned. And therefore, on the basis of said, that said complaint was finally for the magistrate, which was forwarded to the Lakhimpur police station. The Lakhimpur police, after inquiry, came to know that the petitioner are living in the, they are living in the Arunachal, madam. Arunachal. So they had sent it to Arunachal for investigation. After investigation, the report is submitted. And the Commissioner one, they send the report. The descriptions of the non-applied cases on 20/12/2005. She is Durgabara, resident of KB Road, North Lochinpur town, informed by a complaint for the Honorable Court of North Lochinpur that his childhood from day, son of Sri Omar Day and his wife Srimati Gita Roy, and of the sector, Itanagar, Arunachal Forest, has been the document amount of taken rupees 50,000 on credit from him due to some financial trust on their part. And the complaining statement of the accused that they will not return the money has been denied by registered by the officer in charge of the Sodor police station's fight case number 9/24/2005 under section 406, 420, 34 IPC, and investigation started on the basis of the complaint filed by the commission. During the course of investigation, the place of occurrence was visited and witnesses were collected, therefore, but no materials could be collected. And would be collected revealing the fact that the accused took the said money on credit from the complaining. So no evidence because that the complainant the complaint stated on oath that both the accusers say that the E sector, Itanagar, Arunachal Pradesh, AWPS is sent to the concerned police stations at Itanagar, Arunachal Pradesh, from the police station to trace out and arrest the accused. But the OC Itanagar had informed for the operating assets that both the accused had left the place and absconded to an unknown place. That is why they could not be arrested. Therefore, they could not be interrogated in connection with this case. After discussing the matters with the officer in charge of internal police stations and after studying the report of visiting the place of occurrence, he posted a mark that case under section 403 IPC is really established and the officer is directed to advise the submit the affair. So the no materials was collected as taking of money by the accused from the response number 2. If there is no evidence, how case under section 402 IPC can be registered minor without any material to the effect minor. And so the charge and the advice to submit on a non-affair is before the honorable court against the accused city Uttam Day and Srimati Gita Day and SR, I am hereby submitted this
complaint
non-affair case before the honorable court for trial. There is no materials there found that they took money from the petition. Now the act of evidence.
It was registered as a complaint case.
Yes.
And thereafter, summons was issued. Again, against that,
Yes, again,
that must be under order of stay, right? Because of the long time. It must be under order of stay. Stay
yes, stay there.
must be, because otherwise, it's long time. So anyway, sir, I think I have to sit with my second case. So we'll resume. Right. We'll be able to finish. We can resume. I think we'll get time to do this.
Next day maybe fix my own next day.
Otherwise, you'll have to keep waiting.
Then message my, just I can conclude it, yes, there is a 2 points. 1 point, there is no materials have been found about taking of money. Secondly, or it is a non-talk offense, my lord, 403 is a non-talk offense. You submitted charges against that having a non-talk case, the police has to obtain permission from the court under section 155 2 of that.
That was not done.
My lord, no personal offense. So
Infirmity.
no case.
Infirmity is there. Anyway, so if you, I can resume it, or maybe your junior can start and then you can conclude on another day. We can keep it in two parts.
I'm ready to complete if your lordship has inconvenience under the.
No, I'm not having, after completing the special DB, I will sit again. Because all matters are not completed.
At 2 PM also I have other case, so.
Let us try to. But in case you have difficulty, suppose we get late there. Suppose we get late there,
That may be picked up.
then sir wants to go, you can go. We'll accommodate. Or you can start and we'll keep it partner and fix another day.
It's very old case, so.
Yeah, we should dispose of these things.
That may be fixed. After 2 I can speak.
Yeah, we can try. We will keep it open.
That please, Lordship.
No problem.
My lord, item 13, Lordship, maybe some other day, Lordship. 1-3, Lordship.
It's also old
Last
matter.
Item 13, Lordship.
On council 6, adjournment of item number 13. Since being an old matter, petitioner council, both sides are requested. The petitioner council is requested to conduct the matter expeditiously on or on the next or subsequent dates. When should I fix it?
After you, maybe.
21.
Obliged.
And anyone for 12? It will-
No.
12,
13, Lordship.
12 is still there. Paper book is in 12. You can have a look. If it doesn't happen today, your effort will be wasted, but you can have a look. Item 12, there may be paper book also.
But
Huh? 9.
It is 49, 45 of within today.
You join online.
Your lordships.
We do not find any infirmity in the conviction recorded by the learned trial court under section. And the conviction is hereby upheld and confirmed. And with regard to the sentence as well, considering the manner in which the offense was committed and the age of the girl, we are not inclined to make any modification. Consequently, the impugn order, judgment and order dated 9/12/2019 is hereby upheld and confirmed. Resultantly, the appeal stands dismissed.
obliged.
Deeply obliged, your lordships.
Number 10.
Item number 10. He has come. Oh.
Item number 10.
Relevant section of non-FIR is 201,
My lord.
155.
My.
You can take a copy of the CRPC. Just see whether permission of the magistrate was.
Yes, that was there or not.
Yes.
Record to news.
Yeah, this- Ah, okay. No, I don't know. I don't know. Both are disposed of.
My-
Common judgment. Four zero three is non-cognizant. Is it non, just see the schedule. Yes. In a non-FIR case, the charge sheet will be taken as a complaint, right?
Yes, ma'am. এটা হইব। Delivery of those.
I've not seen anything regarding permission.
Yes, my lord, that part I also didn't notice, my lord. Regarding that part, I also not, my lord.
Should we
In the,
adjourn?
in the, my lord,
Should we adjourn it?
because,
Adjourn.
because my lord,
I have some work.
petitioner is also not, my lord.
Yes, otherwise I will not be able to wait actually.
My lord.
He may not be, because actually we have fixed a tool. So he may have thought that that would take
Mile.
some time. You can fix it on Thursday.
Yes, it's not to delay it.
Still. Some learned counsel for the petitioner had addressed some arguments. Would not be complete. Time constraint. This is the matter on Thursday, this Thursday. 26,
26.
I think short matter.
Yes, yes. 26.
Can address it Thursday. None appears on form. Should I direct that translation?
Yes, my lord, my lord, those parts, my lord, yes. My lord, I have flag mark, my lord, PW1, my lord, there is my lord, PW1, 2, 3, 4, my lord. After 5, it can, or my lord, may, only the where, my lord, the vernacular depositions
only
are
the
there,
vernacular.
all definitely,
Only the partner.
vernacular depositions.
The registry requested to get translated and typed the depositions of is the way in the record. Oh, so you mark.
Yes, my lord, in the record, my lord, I have flag mark, my lord, PW1, my lord, then thereafter it will be, my lord, it will be continued. my lord.
W1.
1, 2, 3, and my lord, 4.
This is a bit of a problem. It will be helpful for us.
PW5 also, my lord, there is a re-examination parties in Assamese, but that is legible, my lord.
When is
Yes, but
PW2, PW1, PW2, PW3,
and PW4, my lord. 4 is also there.
PW4,
Yes,
and CW1
CW1.
and CW.
PW5 also some re-examination parties there in Assamese. But that we can take care
And
of.
the re-examination part of PW5.
PW.
After view, they expect some time.
Yes. That may be fixed.
List on 30th April.
I think. My